Managing a team of investigators just got easier with TrackOps, the all-in-one case management software. Are you ready to enhance case flows and drive efficiency? TrackOps offers powerful management and coordination tools to streamline workflows and communication, all designed to keep your team synchronized and focused on the task at hand. With TrackOps, you can easily distribute workloads, track individual performance, and ensure deadlines are met. Plus, the TrackOps mobile app allows investigators to access case activities on the go. And the TrackOps video app allows for simple and consistent timestamping, all included at no extra cost. Start streamlining your investigation process today. Visit trackops.com for a free 15-day trial and experience the power of efficient team management. TrackOps, empowering teams, simplifying management. This episode is brought to you by 4 Pillars Research, a nationwide leader in policy limit searches, now expanding its services to support private investigators working with injury attorneys. Since 2019, 4 Pillars Research has been known for its professionalism and top-tier customer service. If you're a private investigator, you know how crucial it is to provide accurate and complete information to your clients. Research can be time-consuming and challenging, especially when accuracy is non-negotiable. That's where 4 Pillars Research comes in. Unlike other firms that outsource their work, 4 Pillars handles everything in-house, ensuring you receive precise policy limit details of the at-fault party before litigation even begins. With 4 Pillars, you get more than just data. Each client is paired with a dedicated client engagement specialist, ensuring personalized service and meticulous attention to detail. And for those of you handling multiple cases, they even offer loyalty programs for high-volume clients. So if you're looking to elevate your investigative work and provide your clients with the best possible service, contact 4 Pillars Research today. Let them handle the complex research so you can focus on delivering results. That's 4 Pillar Research, your trusted partner in policy limit research. Reach out now and take your investigative services to the next level. Special announcement. Congrats to our very own host, Matt Spaier. He was just named a 2024 Top 100 Entrepreneur by Top 100 magazine. Matt continues to push the envelope for business development in the private investigation space. So big congrats to Matt and the team at Satellite Investigations. Welcome to this week's episode of PI Perspectives. Today, we remember David Perecman. The New York legal community was shocked to learn this past week of David's passing. David joined us back in 2021, and we want to rerun this episode as a tribute to this amazing litigator. Please welcome David and your host, New York Private Investigator, Matt Spaier.
And welcome everybody to this week's episode of PI Perspectives. This is Matt Spaier, your host. Today we are in New York, and I want to welcome David Perecman to the program. David, how are you?
I'm great. How are you?
I'm doing great, man. So,
Thank you for having me.
Yeah, it's an honor, really. You have had such a storied career, and you're very well respected in the industry on plaintiff personal injury. So this kind of a big get for me. So I really appreciate you taking the time to come on and talk with me.
My pleasure.
So plaintiff personal injury, that's what we're talking about here today. We're going to focus a little bit later on construction accidents and understanding the labor law. So as an investigator who's doing that kind of work, really understanding what needs to be in the work that we're getting you. So let's talk a little bit about your firm. You've been practicing on your own with your own practice since 1983. So how have you seen things change over that time?
Well, the time that you're asking about it is during COVID.
Right.
Obviously, the change recently is monumental. We have realized that we can do many things remotely that we didn't think we could do before, and effectively. I hold mediations remotely. I just did a very important deposition 2 days ago of a couple of witnesses in a very serious labor law case, right. Also by Zoom, and I'll be honest, it worked quite well.
Yeah.
Obviously, we can't try cases by Zoom, so
right.
That makes a difference. How have things changed? Less collegiality than there was years ago.
You miss it, right?
I
I know.
do. I do. I will say, however, I think that things are a little more straight up in court than
Right.
they were 40 years ago.
So
Um,
what has been your experience in dealing with judges? And I've had a little bit during COVID, just seeing just a different attitude across the board from everybody, where it used to be like everything was so staunch and how you did things proper. Now it's just like, whatever, we got air in our lungs, we're breathing, right?
I don't know if COVID changed how they respond, and judges vary. Some judges are very, formal. You sit in their courtroom, you have to wait an hour or two before your case gets called.
Right.
And if you take out a newspaper, you violate their rules. They don't like that.
God forbid a phone goes off, you're in trouble.
And there are other judges who are much more laissez-faire, shall we say.
Right.
I prefer something in the middle.
Right. So one of the challenges that I'm having here in New York as an investigator is obviously getting around, right? So during the lockdown, we were deemed essential services. We had our lobbyist really push for that and clarify that. So we were able to get out and go around and work and do everything. So now that things are starting to open up, people are still in the hospital, right? And I'm still getting calls from law firms like, hey, I need you to go to the hospital and meet with people. And it creates such a problem for me because I don't want to endanger my people that work for me. Not all of them, they have their shots, but they're still not thrilled about going into a hospital environment. And then also dealing with the administrative on hospital, because what happens is a firm like yourself will talk to somebody and the person they're talking to and saying, yes, you can come visit. Well, that's not really true. If you're a direct family member, you can, but an attorney, you need to really talk to the charge nurse and really understand the policy of the hospital. And we're running into a lot of problems like that. So definitely we've had to be creative this last year or so, and it's still a problem. I hate turning work away, but it once or twice a week, somebody calls me and says, hey, go to the hospital. I'm like, I would if I could, but we really can't. And I hope that changes soon.
It's also somewhat harder because you don't present the same business card that I would present, for example.
Obviously.
I can go in there. I am an attorney.
Right.
Got a little more gray hair on my head than you do.
Catch that.
And I have the business card of an attorney, and it carries some weight.
There's truth to that.
And
Yeah.
it gets me in the room.
Yeah.
But listen, COVID has changed almost everything.
Yeah.
The world has been turned on its ear. I can't wait for the courtrooms to open back up and for me to be able to try cases. I miss it.
Yeah.
I just miss the conferences in court.
Yeah.
We used to go in the room and you sit and you chat with other lawyers. You get to schmooze with them.
Sure.
And with the court personnel, I miss all that.
Yeah. Yeah. I mean, it definitely, I would say I'd relate it a little bit to like 9/11, right? So when that happened, the whole going to court was a very weird experience too. Getting into the courtroom, the building, these policies and procedures. I mean, it could take you about 2.5 hours. You had an attorney card. I didn't, and agent of an attorney didn't matter. So if I had to go to court for something, you had to put that time away. So the dynamics were different. And I think even now, like, the dynamics are going to be different when things open back up. Right. So, what is that going to look like, and it's like, now you're interviewing a potential juror. Like, do you have the right to ask them if they're vaccinated or not? I don't know. It's a weird question.
We don't know the answers to a lot of questions.
Right. Yeah. You don't want somebody getting sick when they're on your panel, right? Is that question going to be allowable? That's really an interesting question to see how they handle it.
It'll be interesting to see how it develops and how it pans out.
Yeah.
And I think whatever we'll start with will not be what we end up with. It'll morph.
Good point. Yes.
It'll change.
It will definitely change. But I think it's time, though. I mean, it's good to see things starting to open up.
Yeah, I'm happy. I'm really happy.
We have a window here. It's
nice
more than just.
Go ahead. I'm sorry.
Yeah, it's more than just going out to eat. It's like life in general needs to.
Yeah. It's nice just to be able to walk down the street without a mask on your face.
I tell you. Yeah, it's especially when it gets hot out. It's a little difficult. So you have handled all different types of law. I mean, and you've had some very big cases too. Taking a look at your career, it's been impressive. Is there anything that kind of sticks with you? Something you're most proud of, or really like at the end of the day, you're like, wow, that was pretty amazing to be involved in that experience.
We don't do a great deal of it, but we do handle some cases involving malicious prosecution and false arrest. And it turns out that one of those cases is, to me, my most rewarding moment. It involved a woman who was an illegal in the country, a Mexican woman who spoke no English and was of very limited intelligence, and was in jail for 4 years pending prosecution for allegedly stabbing and gutting a man 21 times.
Oof.
If you took one look at this woman, you would know that she was not capable of anything of the sort.
Right.
But the police did what they did. They arrested her. They indicted her. They extorted a confession from her over 22 hours. And the city of New York, who was the defendant in the case amongst multiple police officers, made a motion for summary judgment, which means we win, they lose.
Right.
And the judge in Queens County agreed with them and dismissed the case. We appealed it to the Appellate Division Second Department because we thought we had very compelling evidence that the way the police conducted this entire investigation, including coercing a confession from her, warranted reversal. It was a unanimous decision, and we lost. And at that point, you're stuck.
Right. And
the only thing you can do is ask, or rather beg, the Court of Appeals to see the case. Right. And a motion was written by three of us in the office, including my son, Zach, Peter Riegelhaupt, myself. And we wrote a motion to the Court of Appeals basically saying to them that these kind of cases in this posture, the way the law stands, a certain presumption that exists from an indictment of probable cause, that they get handled one way in the federal courts and a different way in the state courts.
Right.
And that shouldn't be, and that they should hear the case. And they heard the case and they reversed the decision.
Wow, that's amazing.
And reinstated the case, and the case went on. It appeared in Queens County trial court shortly thereafter. The city realized they were now not in such a great position, and they settled the case for $4 million.
Yeah, and when I first got into business, I worked on a case that was a civil rights violation case, right? It was a big, huge case, and it was up in the Bronx, and it was in front of a judge named Stanley Green, who, a character, right? I'll just leave it at that. A big, huge case. They ended up, the jury came back with like an $80 million verdict, right? It was unheard of. The biggest injury was a fractured nose.
Bronx.
Yeah, it was the Bronx, right? So Judge Green got so angry, he sent the jury back. He's like, you obviously didn't understand my instructions. Go back now and deliberate. So they came back 2 hours later, the same exact $81 million, right? And I never forget it, right? Because I'm literally just about to go into business, and this was the attorney I was working for before I started my business. And Judge Green looks at the attorney and he goes, "Your clients are never going to see this money ever." I was like, wow. So it goes up.
Well, they won't.
Well, this is what happened. It went up on
not 80 million, but they're going to get some of it.
No, it gets worse, right? So it goes up on appeal. The city's now like, oh, wow, we just got banged for $81 million. Here's $9 million. Take it or leave it. And the group of people were like, no, we're not taking it. We're going full route. And, went up on appeal and they lost everything. They didn't get a dime. Nothing.
Nothing?
Zero. Yeah.
With a $9 million offer.
Yeah.
Oh, God, how do you explain that?
You never know, man. There's nothing guaranteed. I've seen somebody trip over a rat and get $120,000. I mean, this industry it's interesting,
It certainly is interesting. I'd like to think that more times than not, the results that come out are just.
Yeah. Yeah. And I'm curious how that whole civil rights, violations and stuff like that in today's environment over the past 2 years would be very different than it was, let's say, 10 years ago, right?
Oh, it is different because now Now the prosecutors have departments that go over. They look for people who have been convicted, who should be exonerated.
Right.
It's more transparent than it used to be. And in fact, the decision in our case, the Torres case, changed some of the rules about how you view these cases, and it changed the question about the presumption of probable cause, which is what you need in order to hold hold the plaintiff's feet to the fire in one of those cases. And if there's, let's call it, bad conduct on the part of the police, improper conduct, coerced confessions, hidden evidence, they lose. Or at least the plaintiff doesn't lose and has a shot to go to court and present their case to a jury. And it wasn't quite like that in the state courts before Torres. So at times it has changed. It has changed.
That's pretty amazing that your case helped grease the wheels on that. And believe me, I'm as pro police as the next guy. Obviously, the industry I'm in, but not everybody's a Boy Scout. People do things they're not supposed to do. I think one of the other interesting things too is body cams. I think that's kind of changing, how things are happening here. Folks knowing that they're being recorded, but it's beneficial on both sides, right? The officer knows, hey, if I'm on the straight and narrow, the truth shall set me free. And the other people, when you go and you're starting, something happens and they see the camera on the body, they're like, okay, I'm not going to, I'll behave myself because I know this could not end well for me. Right.
Yeah. I think body cams are a wonderful invention and a wonderful addition to the police department. It keeps the police on the straight and narrow, and it keeps the people who are being policed on the straight and narrow. One thing's for sure, like you said, pictures tell the truth.
Yeah.
That's why you do what you do for a living, because one of the things that you guys do is you get videographic and photographic proof.
Right.
And pictures are pictures. Can't change them.
Can't change.
You can, but
well,
not properly.
I got a whole teaching on that. John Alfredi is my mentor, my guru when it comes to photography. Just amazing guy. And I was actually just at a conference down in South Carolina this past week, and there was a gentleman who was doing a presentation on photography, and he had called me before he did his presentation. He said, "I saw your webinar, and I'd like to take some of the information you have on there for it." I was like, great, I'm actually going to be at that seminar. So yeah, perfect. And there were some questions that came up along the way, and I couldn't help but raise my hand and interject because, that's what I do. Yeah. And it was like, I'm laying John Alfredi's nuggets on everybody. It's like the gift that keeps on giving, because he really, really helped me. And there's another attorney, a guy named Leo Vinides, that just along the way, no, you did it wrong, go out and do it this way. And he'd send me back out to do things. And, trial and error makes you get better.
You learn.
And it gets tricky when it comes to construction cases and things like that. So we're going to actually take a break. And when we come back, we're going to start digging into labor law, because that really is what I wanted to talk today about.
Okay.
And just setting the table for the investigator, understanding when you do this type of work, what you need to do. So everybody sit tight, and we will be right back.
Do you enjoy our podcast and the guests we bring you? Since 2019, Matt and his team have done their very best to give you amazing shows each week. If you feel like our show has helped you to be a better investigator, or maybe even inspired you to become an investigator, please let us know. We're looking for testimonials. Drop Matt an email with a recorded 20 to 30 seconds of you talking about this podcast. You can also email him something verbal about the website. His email is matthews@satellitepi.com. And if you really feel blessed for having this content, consider supporting Matt and our show by joining Investigators Toolbox. You really have to see version 2.0. And at just 49 cents a day, it's a no-brainer. After 4 years of development, Scope Now is proud to announce the release of Grid. Grid combines OSINT with real-time physical data to achieve new levels of intelligence gathering. Grid supports over 50 data types and hundreds of thousands of sources. Upgrade your OSINT capabilities with Grid and elevate your intelligence team today at scopenow.com. The Campbell Group has teamed up with PI Perspectives to offer listeners top-notch, affordable insurance solutions. Private investigators can get insurance for their business for as low as $305 per year. Apply now at piperspectivesinsurance.com and receive a quote back within 24 hours. Check out the PI Institute of Education at piinstitute.com. Since 1989, Kelly Riddle has been teaching on subjects such as surveillance, nursing home investigations, insurance fraud, domestic investigations, hidden assets, and accident scene investigations. The PI Institute of Education is a featured learning partner in the investigatorstoolbox.com. So check out the free content on the site, then visit the Institute for more great savings on additional classes. Over the past year, our industry has been the target of foreign governments and agencies that have attempted to recruit unsuspecting investigators to gather intelligence or immediate expatriates. PI Perspectives is teaming up with the Federal Bureau of Investigations to get the word out about this ongoing crisis. If you've been contacted by an individual or company that might seem suspicious, please contact the FBI at tips.fbi.gov. You can also contact the New York field office at 212-384-1000 to report suspicious activity in any state. The link is also in the show notes. Even if you completed a job and it still doesn't sit right with you, you can report this activity. The only way to stop this trend is to work together. So let's do it. Satellite Investigations has launched its new website full of great new content. Matt and his team have released some great informative blogs. Make sure you log into LinkedIn and follow Satellite Investigations for the latest content.
And welcome back to PI Perspectives. This is Matt Spaier, your host. We're here with David Perecman. And David, I want to welcome you back to the program.
Thank you.
Okay, so the purpose of this conversation today really was supposed to gear around labor law, construction cases, and I want to dive into that topic now. So you obviously have had a long career doing these types of work, and I would say, what would you say would be the number one mistake an investigator that you are working with makes when they're diving in to do this type of work?
The things that stick out to me is getting statements from people that they think are beneficial for the case, but isn't really what the witness wants to say.
Right.
I always tell my investigators, do me a favor. Don't try and get them to, say things in a way that benefits me. I need to know what they really intend to say, because I don't want to be sandbagged later on. And the other thing that sticks out to me the most is in these labor law cases, the law is nuanced, and you have to know what it is that the plaintiff needs to establish to win their 240, 241-6 or labor law 200 case, so that you can weave and bob with what the witness says. And they may say this, and you say, and then you'll turn around and say, okay, but what about that? And they may say something else, and it'll be enough.
Right.
The classic example I give is if you have a case where a worker falls from a ladder. The ladder wobbles, it falls, the ladder falls, they fall. That is a case that, absent unusual circumstances, the plaintiff should win summary judgment on motion. That is not a case that will go to trial likely on liability, maybe on damages, but not on liability.
Right.
And really all the investigator needs to establish, it's nice if the ladder was broken, it's nice if the ladder was old, it's nice if the ladder was wobbly. All those things are nice, but all they have to prove is that it was unbraced, unsecured, and that it wobbled and they fell. And many times they go up to a witness and they'll say, well, did you see the accident? And they'll say, no.
Yeah.
But there's more questions to be asked after that.
Sure.
Did you hear the accident? And they may say, I did. And what'd you hear? I heard a bang and a thud. Well, what did it sound like to you? It sounded like something like somebody hit the ground and then like maybe a ladder hit the ground, something wood or something metal hit the ground.
Right.
And did you look and did you go over? And yes, and what did you see? I saw the plaintiff on the ground and they were next to the ladder. Was there anyone else nearby? No. Did it appear to you that there had been anyone else nearby who was holding or bracing and securing the ladders? No. Was there anything around the ladder that it was braced and secured with? No. Case over.
Yeah, there you go. Yeah. And that's the thing. And you do get that a lot, right? So when you're talking to people, usually depending on the type of work they're doing, there could be teams of people doing work, but it could be, guys solo doing whatever. And, the coworker maybe is in the other room, and it's like they first become alerted of the incident after it happened. But that, hey, lay the foundation for me of what you saw when you went over there. So important. I think what the points that you're making, really, really important. So let's talk about the nuances a little bit, the different labor laws, because I mean, this is New York. So, if you're an investigator from another state, do your due diligence and understand what the labor laws are in your particular state, but we're focusing on New York here. So when you say labor law 200, 240, and 241, break that down for somebody who really wouldn't understand what that means.
Labor Law 200 is really what we call a codification of general rule, general negligence, requiring employers to provide a safe place to work. That's basically what that's about.
Right.
And it can be any kind of negligent condition on a construction site. Holes left in the floor, objects left on the floor, debris left on the floor, snow and ice.
Right.
All types of conditions. But the people who really get sued, although the employer is required to provide the safe place to work, are the owner and general contractor.
Right.
Because they're the ones that can be responsible. But in a 200 case, you have to prove that they were involved in the negligent act. That's tough generally with an owner.
Yeah.
Because they're usually not on site. Maybe the GC.
Tool time. Toolbox meetings. That's what does it.
Right. Exactly. 241.6 is different. 241.6 together with 240 are both vicarious liability statutes in essence. In other words, if the employer failed to provide a safe place to work, it doesn't matter whether the owner and the general contractor were involved in that. You're an owner, you're a general contractor, that's your subcontractor who the employee was an employee of. You're responsible for the failure to provide the safe place to work. Now on 241.6, it can be all sorts of different types of negligence and failures, similar to 200, except the only difference is in 200, there are no boundaries. It can be almost anything. In 241.6, it has to meet one of the regulations in the NYCRR, the New York Code of Rules and Regulations, and that's a 1972 or 1976 set of regulations. If it doesn't fit into one of those regulations, you do not have a 241.6 case. Right. But the regulations are pretty expansive and they cover a lot of things. And when an investigator goes to an accident that's not necessarily a height-related accident, which is 240, as I'll tell you in a moment, they should speak to the attorney and ask them, what regulations are you thinking I'm going to be looking for here? And get a copy of those regulations and read them. Yep. And see what it is you need to prove, because they can be pretty narrow and focused. And you need to prove it within those regulations. As I said, no regulation, no 241.6. Yep. You may have a 200, but not a 241.6. But under 200, you need to prove that the GC supervised and controlled that particular act, whereas on 241.6, you do not need to prove it. The owner and GC are vicariously responsible for the acts of other people who are underneath them. Right. And then there's 240, which is the big dog. 240 is the gravity-related section, and that is falling objects, falling workers, and things similar to falling objects and falling workers, because if something happens as a result of gravity, it's not necessarily a worker who falls or an object that falls. But for example, there's a well-known case called Runner, where they were lowering a reel of wire, a big reel, down a staircase. It was a short staircase, 4, 5, 6 stairs. And they were using a pole at the top of the staircase that they wrapped the rope around, and they were pulling on it to hold it, to keep it from going wildly down the stairs. Well, they couldn't. It went down the stairs, and the worker got pulled into the pole and injured their hand. That was 240, because the reason the roll went down the stairs, the reel rather went down the stairs, was due to gravity. Yeah. And although the worker wasn't a falling worker and it wasn't a falling object, that's 240 also.
No, I had something similar. I had an elevator case where the counterweight, I guess they malfunctioned in some way, and there was some line that was connected to the elevator. And as the counterweight fell and it started to go down the hole there, the rope wrapped itself around the guy's leg and actually pulled him up and he hit the top of the elevator.
That's 240.
Yeah. Yeah, very interesting stuff.
That's 240. So 240 is a pretty expansive statute.
Right.
And again, one of the things I think an investigator should do before they go to a site and they're going to investigate an accident, understand it may be 240, it may be 241.6, it may be 200, it may be all of them. Right. Investigate the various aspects and speak to the attorney and get the attorney to lay out, what are you looking for?
Yeah.
What do you need from me, so I know what I should look for? What kind of photographs, videos, statements, right. What kind of evidence are you looking for? What kind of documents are you looking for?
Yeah, just, setting you up for a win, really understanding it. I definitely have a bunch of clients I work with where I do have that relationship. I gotta say, it's great. It makes me feel good too, because it makes them like they trust me to understand, to know what they're looking for.
Well, they should.
Yeah, it's they good.
Should. I've had circumstances where I've told an investigator, particularly ones when they were newer to me, when you get to the scene and you meet the witness, pick up your cell phone and get me on the phone with them.
Yep. And
let me have a conversation with them, with you. And because I'm going to be able to weave and bob my way through the labor law a little more easily than somebody else will. And I'll help direct them and then say, okay, now we got what we need. Yeah. Now sit down, write it up. And in labor law cases, my suggestion is you don't just get a statement, you get an affidavit.
Oh, everything. I mean, I do it on all personal injury cases, sworn to before me. I've read the statement under the penalty of perjury. Have to have that under the penalty of perjury with an affidavit, and now it's a sworn statement. If you don't do that, you've pretty much just guaranteed that guy that he's getting subpoenaed. I mean, he's probably going to get subpoenaed anyway, but
probably going to get subpoenaed anyway.
Motion for summary judgment. If you don't have that affidavit, you're not getting there, right?
Right. Statement is not admissible.
Yeah.
You might be able to admit a statement in opposition to a motion for summary judgment if they offer testimony of that witness and you have a statement where they said something different.
Right.
In opposition, yes, but to make a summary judgment motion as affirmative evidence, you need an affidavit. You're right, sworn to before me under penalties of perjury, notarized at the bottom.
Yep. So have you ever come across a situation where you've had that phone conversation and now you're deposing or doing, calling them in to testify, and the whole question about have we ever met or talked before? Because I know that's an angle some of the adversaries bring upon, right?
It just happened the other day. There was a focus by the attorneys because they didn't like what the witness had to say on meeting. Did you meet with me? Did you meet with the plaintiff? And it happened this particular witness happened to have run into the plaintiff on the street.
Right.
They spent a half an hour on that. But yes, and the answer to the question is yes. It's uncomfortable when they go, have you met with the attorney? How many times did you talk? Did you discuss the case? And the worst thing that a witness can say is no. Now, if they haven't, great. But if they have, Don't lie.
So, yeah,
Don't lie. Yes, I met. Did we discuss the case? Of course. Did the attorney tell you what to say? Yeah, he told me to tell the truth.
right.
And what did you discuss? He asked me a ton of questions. I gave him a ton of answers.
Yeah.
And every answer I gave him, he asked me another question. And it went back and forth like that till we had gone over everything. And then he said, good, thank you. And I appreciate it. Happy days.
Right. I think it's much easier when you're deposing that person to put it out there, right? Rather than the other side bring it up, right?
Yes.
You're lessening the blow, essentially.
Yes. You say we met.
So, yeah, it's important.
And it also prevents them, when the other side says it, from having that instinct that they need to lie about it.
Yeah. Yeah. It's so hard, and I got to say, one of the bigger problems I come across when doing this type of work too, is convincing the person, that they want to get involved, because it is such a small industry and they're afraid, like, I'm going to get blacklisted, like I can tell you everything you need to know on your case, but I'm worried that, I'll get thrown out of my union, or, I'll never get hired anywhere to do anything. And how do you answer that? It's like, I don't know the future.
It's a very difficult situation. And in that case I mentioned to you the other day, there were two gentlemen who testified, both of whom were in very similar physical positions to observe what had happened. And the first one miraculously saw nothing.
Right.
I don't remember anything. I didn't see anything, despite the fact that when the Department of Buildings came to the site, he did see things and he told them what he saw, but he didn't see anything. And it was funny because the other guy, they didn't have much from him, but when he testified, he watched the whole darn thing. And you could see, he was in his employer's office when he was testifying. You could see the discomfort, but he also knew that my client was badly injured and he wanted to do the right thing and say what he really saw.
Yeah. Yeah. And
but it's hard.
One of the other challenges is I'm missing work, right? And, am I going to be compensated for my time? And that's a slippery slope, like, will the attorney pay you to come to your deposition? And there's a way to handle that, right? And I think each firm handles it differently. And I know the Bar Association has opinion on this stuff, on what's proper and what's not proper. I'm correct me if I'm wrong, but I'm always like, if they show up and they show what they make, you can compensate them for travel time. You can compensate them for the time it takes for the deposition and the return trip home. Is that correct?
You can compensate them for their loss that day. If they would have made $90 that day, you can give them the $90 and you can give them their transportation costs.
Right. Yeah.
They shouldn't have to lose a day's work
to
come to a deposition.
Yeah. That's one of the big challenges. And interestingly enough, now that we've got this virtual life that we're all doing, we all understand Zoom and having depositions on Zoom. It's been my experience, what I'm seeing so far, it's a lot easier to get these guys to commit, that, I just got to turn on my computer and, my 2 hours instead of taking like half a day to go, travel and go down and do whatever. So I think it's greasing the wheels a little bit.
Absolutely.
Yeah.
Absolutely. And getting them scheduled is easier because people are home. Yeah. And when you have multiple attorneys involved, I'm home. Well, yeah, I got 2 hours that day. I can sit down at a computer for 2 hours.
Right.
That's a whole different, it's a horse of a different color when you got to get up, put on a suit and tie, and you got to go into some place in another borough in the city. And it's a whole process. Yeah, it's great.
I think it's here to stay. In many ways,
it's great.
Yeah, I think there's going to always be some sort of hybrid thing going on here. We've kind of proved that we can handle that technology, and I think it'll move cases, which is really great. That you can get these things out of the way and do what you need to do.
I think it's great. Are you able to do certain things with Zoom, with interviewing witnesses and stuff?
Yeah, so we are able to take notarized statements if the person is in New York State. So they basically have to prove they're in the state at the time that we're interviewing them, because that was a big deal during COVID too. So the governor, I think it was 202.7 was the executive order. They keep extending it. I got to actually take a look and see if it's still extended, because last I checked, mid-May is when it was extended to. So yeah, I gotta go double check. And that's been a blessing and curse for my business, right? So the blessing is, hey, I'm able to actually do work during COVID and make money and whatever. the curse of it is, so is the attorney who would hire me, and he's not doing much these days. So instead of hiring the investigator to take that statement, or maybe I'll just have somebody from my office do it, right? Which is not, in my opinion, is not the way to do things. It can hurt you later on, but some of them have been doing it.
Sometimes an attorney can scare off a witness.
True. Yep.
And in many circumstances, the investigators are more skilled at talking to witnesses, talking to people, getting them to feel comfortable with them and give them information. When it's a lawyer,
it's a patience thing too. Like you got tons of other stuff to do. If I can really hone in and focus on what I need to do, you just get a better product. And the worst thing you can do is send, George from your mailroom to go and do something or take photos and all that, because it's just falling under the scope too of this is an employee of mine, and, it just creates problems.
Yeah. Listen, George from the mailroom is not the person to send to take pictures.
Yeah, definitely.
Because you never get the right pictures.
Right. Yeah.
Like you said, ask John Alfredi. He'll tell you about pictures and how you take them, where you take them, and how many times have I told people, my clients that live down the block from something that something occurred, and go to the scene. I'll get an investigator out there, but it's going to take a day or two. If you have the chance, go to the scene, take your cell phone, take it from this angle, close up, backwards, this way, that way, and you get back this bunch of blurry, horrible junk. They take a picture of a defect and they take it real close. It could be anywhere because they never backed away to show you where it was.
Yeah. Yeah.
So that's why we need people like you.
Yeah, I appreciate that, man. So one of the questions that during the conference that came up that I had to raise my hand and say something is somebody had asked a question about, do I take a picture of the ruler? Like not of the defect. Like, let's say it's one of those walking measuring things. What do? I just take a picture to identify it. And I'm like, don't do that because you've now invited the attorney to tell you to bring that with you when you go get called to court, and it just creates so much nonsense. Like just buy a Lufkin ruler. Everybody knows what a Lufkin ruler is. Have it available if you need it and use that, right? No one's really going to nitpick like that. But one of the other things that I always do too, and John had told me this, take a picture of the defect, with the ruler and the exact same picture without the ruler. So if there is any question about the validity of that ruler, you now still have a picture of the defect if you need it, right?
Very smart.
Yeah, it's just good stuff. And interesting, this guy I met down in South Carolina, he actually brings chalk with him, and he'll measure out and make like a live diagram where he's after he's done his initial workup, now he's chalking things on the ground. I was like, wow, that's really interesting. Perspective of a juror looking at a picture. Okay, now I'm seeing the lines like on the picture.
Yeah. Kind
of cool. Not a game changer per se, but just something a little extra and different I thought was really cool.
That makes sense.
Yeah.
That makes sense.
Yeah. Yeah. So it was good stuff. I know the other thing too, like as an investigator, what would be your recommendation if somebody has concerns about subpoenaing? Like, hey, am I going to get subpoenaed and called to court? What would you say the investigator how should they answer that question?
If we're talking about a labor law case.
Yeah.
Okay. The answer is, if we can get clear and specific enough in this affidavit, and there's nobody who can say anything different than this affidavit, you may not have to ever get subpoenaed to court on this case.
Yep.
Is it possible you may be? Yes.
Right. So here's how I answer that question, right? So I tell them, at this point in time, the attorney I'm working with does not intend to call you, right? This should hopefully solve our issue, but I cannot make any guarantees that no one will knock on your door again. I can't make any guarantees that the other side won't say, hey, we want our shot to take a look, to talk to this particular person. I make no promises.
Good answer.
Yeah, it's really important. Never promise somebody, oh, you'll never hear from me again or anything like that, because the second they do hear from you again, they're going to be pissed. Like, no,
I agree with you completely, but that's a good answer. Yeah. It's a different way of saying what I said. If we do a good enough job with this, with whatever you're going to sign for me, this affidavit, you shouldn't hear from me again.
Yeah, it's almost like this is the purpose I'm meeting with you, so we don't have to do that later on.
Exactly, it is.
I try and do it, and sometimes I've had situations where somebody has talk to me verbally. And New York is a one-party state, right? So we've got the recording. It's all good. And that's good for many reasons, right? You need to refresh your memory later on, or somebody says, he said this, he gave me money of this, or this and that, or promised me this. We got recordings of everything, right? So I've done the phone interview. Now we want to do the in-person. They're like, no, I'm not doing it. Forget, I want nothing to do with it. And I've seen situations where attorneys have actually subpoenaed people and then have me follow up with a phone call like, hey, you got that subpoena now. I told you it was coming, and or I told you it was a possibility it could come, right? You never want to threaten them with it. Now that you've gotten it, instead of going and wasting the half a day, how about you let me come out and meet with you and we just get this thing out of the way? I'll come to you at night, whatever's easier around your schedule the weekend. That tends to work a lot too.
Yeah, that makes sense.
A lot less.
That makes sense.
But you never want to tell somebody, oh, you're going to get subpoenaed. You definitely don't want to do that because duress, right? You don't want to create that,
No, you don't want to threaten.
Like I had to sign this or else, like, no, we definitely don't want to do that. So yeah, it's a real animal, interesting thing to do. So I would say, and we're going to wind things down here. I would say, like, if you intend on doing this type of work, you really want to understand what you need to do and what you need to get you as the attorney what you need. Right. So I think this whole idea of reviewing what the laws are before you go and having that conversation with the attorney, that's gold right there. And if people's heads are spinning right now, I actually have the labor laws. They're going to be in the show notes. So I'll throw that up there. If you're in New York, you can, obviously review all that stuff. If you're in your own state again, do some homework, figure it out, and
different.
Yeah, and get your clients what they need. Any parting advice for investigators here, Dave, on doing statement work?
Never give up.
Right. Tenacity. That's a good one.
Never give up.
Yeah.
There's times a witness is going to try and evade you and make it difficult, or they just don't want to be bothered. Don't give up.
Yeah.
Keep working them, try different methods, and you'll get there and you'll get what you need. Definitely. How do folks get a hold of you if they have any questions? Nowadays on my cell phone, but usually my office number is 212-977-7033. It's also, we have a vanity number, 718 workers. Awesome. Which is easier to remember. Yeah, and we'll throw all that stuff in the show notes too. So, but you can find me on my website, Perecman, Perecman, Perecman.com. Easy. There's a whole chat system in there, and you can just send a message my way. It'll come to me. If you want me specifically, you can ask for me specifically, and usually I'll get back to you within a matter of hours. Awesome. So, David, I really appreciate this. I mean, it means the world that folks like you guys take the time to educate, your vendors essentially on what you need to do on this stuff. So, well, I'm honored that you asked me. I appreciate the opportunity, and maybe we can do it again sometime. Definitely. I'm sure there are tons of subjects we can talk about. Car accident case is a whole nother animal. So. Yeah, that's a whole other animal, is right. Yeah. All right. So thank you everybody for tuning in, and we'll catch you guys next week on the next show. Thank you, Matthew. You're welcome.
Thanks for checking out the show. David was definitely one of the industry leaders here in New York. We're looking to get out some more content the rest of the year, and we'll be back with a regular full schedule in January. We also like to thank Four Pillars Insurance for sponsoring the show. Additional thanks to Campbell Insurance Group, Track Ops, Scope Now, and PI Institute for Education for sponsoring our podcast. Also, don't forget about investigatorstoolbox.com, where you can type in Perspectives 50 to save $50 when you join up. Please also follow Matt and Satellite Investigations on LinkedIn. If you have a question or a comment about the show, email Matt at matthews@satellitepi.com. You can also find him on LinkedIn, Instagram, and Facebook. We want your feedback to bring you the best shows possible. And we'll be back next week with a new show, so make sure you tune in. Please stay safe out there.